Boa tarde a todos. Nos escutam bem? Sim, já estou vendo aqui que sim. Então, eu vou conduzir, eu e Vanessa conduziremos em inglês, por conta em respeito aos palestrantes, então já vou mudar para a língua inglesa. So, good afternoon, everyone. We like to thank you, ABPI, for this opportunity to be the moderator of this panel. Together with my partner Vanessa Ribeiro. Vanessa is going to summarize the purpose of this table topic that is related to 5G technologies and patents. And I'm very honored and grateful to present the speakers of this session. So we are going to have two very experienced and experts on standard essential patents and this type of patents and technologies and 5G technologies. So I'm very honored to present Mr. Robert Earle. Mr. Robert is responsible for driving Ericsson's global patent assertion and enforcement activities. Robert supports licensing negotiations and takes the lead in relevant technical discussion, and is a key person for any necessary litigation to enforce Ericsson IP rights. So, Robert, thank you so much on behalf of ABPA for joining this session. And the other speaker is Mr. James Boone. He's a partner at Bristol's, a very well-known UK firm. And James specializes in IP litigation matters, including cross-border, and has extensive experience in advising on patent disputes in the telecommunications, electronics, and other fields. And James has advised on a number of high-profile IP disputes, including acting for Aerotel in a ruling on patentability of business methods and software patents, and for Philips in a successful patent claim in the field of human-computer interaction and computer vision. So, James, thank you so much also for joining this table topic. We are very honored to have you and Robert here with us. And just to present myself, my name is João Cunha. I'm a partner of Guzmão e Labruni firm. I'm in charge of the litigation practice of the firm, together with Vanessa. And so I will leave Vanessa just to present the purpose of this discussion and to give a brief introduction on the topic and how it's going to work today. So, Vanessa, thank you also for joining.
Thank you, João. Thanks again, James, Robert as well, ABPI for this marvelous event and for organizing this panel along with Guzmão and Labruni as well, for everyone in the audience hearing us speak today about this very, very relevant topic. 5G is a cutting-edge technology that we have been able to see on the news, either because of the war U.S.-China, or because of all the implications that technology brings, and the marvelous features, of course, that it brings with it. There's no doubt that 5G is going to change the way we see connected devices. 5G, however, will certainly bring a new round of licensing disputes and potential litigation. And thus, I guess that the success of this technology will certainly depend on an adequate response to the licensing and enforcement challenges presented by 5G so-called standard essential patents. In this sense, the way we organize this panel is that we will first address, through a presentation from Harvard, the 5G technology itself, followed by a presentation from James on the lessons learned from the previous technology standard licensing and litigation activities. The presentations will then be followed by a round of questions from myself and João. And please engage throughout the session by sending questions through the icon you see, Bate-Papo. right, through the chat. And at the end, we'll leave about 10 to 15 minutes for the ones who want to interact live with our speakers to ask questions. So with that said, and without further ado, I will turn to Robert to begin his presentation on 5G technology. Robert, thank you again.
Yes, thank you both for the kind introduction and the overview of the topic today. I'm going to go ahead and share my screen to be able to kind of go through some slides to give you a little bit of background about the, where 5G has, where it's been, where it's going. Let me see. Do we have that yet? Okay.
Yeah, it's quite clear. Yeah.
Okay. So what we're going to talk about today, and again, my special thanks to ABPI for the invitation, and glad that we can join you today. So look at this, first of all, as Ericsson at a glance, and what we're looking for here is to understand where we've been, where Ericsson's about, and also take a look at where we're headed, and maybe give a little bit of an overview about how standardization works and how the importance of the patent process is to the sustainable innovation. Ericsson initially as business areas includes networks, digital services, managed services, technology, and emerging business. Just to give you a little bit of our background, the company was first founded in 1876. We're heading 180 plus countries, roughly about 95,000 employees. But this next number, I think, next two numbers are very important, right? Ericsson has almost 25,000 people working in research and development to continue it and to stem the growth of innovation. And as a result of that innovation, we currently have approximately 54,000 patents worldwide. Ericsson has a very, very long history in Brazil. I was actually, when we did the research on this, surprised at how far back it does go. But the first telephone came to Brazil in 1892. And as you can see from the slide, a progression of time to where I think Brazil plays a very important role in Ericsson's history, and hopefully Ericsson's had an impact on Brazil's history as well. We recently hit the 95th anniversary of our operations last year. We're also very excited and very proud of Mr. Da Silva, was our inventor of the year in 2018, a very, very sharp individual, which is a Brazilian native. So very, very glad to have him as part of the company and part of the team. If you look back, and sometimes when you try to think about 5G, when the public hears about 5G, they hear about it maybe 2-3 years ago. But in reality, as you can see from this, the road to 5G started back in 2011, and it's a very, very slow progression. In fact, I will tell you now that we're working on 6G as we speak today. But you can see in 2011 when they came out with discussions with the mobile infrastructure vendors and to look at what was going to come behind the 4G process. And then they worked with the MTIS project and working with universities, and it began to gain more momentum. As you can see, the tech concepts began to develop and move forward. And in the early 2015-16 timeframe, we began to get some awards recognized for contributions. At that time, you're starting to see that the standard began to coalesce. Moving forward to 2016, Ericsson did something that I don't think has been done before in the world, and that was to initiate a landmark 5G patent application. It's one of the largest in the world in terms of inventors listed and the scope of the technology. It's a very, very broad patent. We haven't checked with Guinness Book of World Records, but I'm guessing it's probably the biggest one that's ever been done. You continue to see record-breaking field trials that occur in that time frame, and they were progressing on into multiple 5G new radio trials. And you see network testing, and now, as you've seen across the globe, 5G infrastructure markets emerging. So what will 5G do besides just increase benefits for cellular technology? We're all talked a good bit about the degree of latency or lack of latency in the 5G technology. I've often told a story that I saw once at a demonstration where they had a robot that would catch a ball. But you would talk the robot through 4G technology, and when you drop the ball to the robot's hands, it missed because the lag time between getting a signal to the robot and then making his hands move. If you do the same exercise with 5G, the robot catches the ball. And that's maybe the cleanest way to understand really what a difference it makes with the latency issues that we have here. But you will see different verticals emerge here, massive machine type communication, anything from just all type of processors going back in to let you know you need to repair something, it needs to be emptied or changed, et cetera, for that. I think you'll see definitely an enhancement in large venues, and you're going to see, again, additional fixed wireless access. I think there's always been a hope, too, that 5G will help bring internet communications and cellular connectivity to people that previously may not have had it because of the remote locations and difficulty in getting infrastructure back to them. All right, so oftentimes you hear people talk about an SEP, and that's a short way of saying Standard Essential Patent. What is that really about? Well, there are standard development organizations called SDOs. Those organizations are put together really to help adopt a standard. When I'll speak about that in regards to cellular connectivity, it's very important to understand, right? You want to have a phone that you can leave from Brazil and go to Argentina, or go to the US, or go to Europe, or go to Asia, and it still work. And the way you achieve that is have a common standard across all those, so that you build the phone a certain way. It's able to handle and transmit the signals a certain way, so that you don't have a country by country type of fragmentation, which would mean you have to have a briefcase full of phones if you're going to travel much internationally to be able to communicate. The combination of the standard and standard process is also an interesting thing as well. The way that's generally set up is that there will be a problem will come up, or something needs to be solved to advance the technology. Oftentimes, the different engineers in the meetings will present different ideas, and then they will vote on those ideas, and the best one goes into the standard. And that becomes part of the standard that will be carried forward for the rest of the thing. Now, there's an interesting thing that happens here, though, right? Because as you may be asking yourself, well, if you get the type of technology in the standard, does that not give you an unfair advantage? In other words, people have to do what you just put into it. So therefore, don't you have a leverage over that person in any type of business negotiations for a license? And the short answer is theoretically, yes. But that issue has been resolved by what this, and in particular Etsy uses, and other ones use as well, is basically you declare if you have a patent on the technology you just submitted, and you would declare to Etsy that you have that patent, and then Etsy will say, fine, I'm going to take this information into the standard, or this technology or innovation into the standard, but in return, I want you to make a promise to me. And that promise is that you will agree to license this technology on fair, reasonable, and non-discriminatory basis. And thus, the buzzword you often hear people say, FRAND, and that's what that's about. So that FRAND obligation is there, and initiated by the declaration process, is used to be a check on the patent holder to ensure that they do operate in a fair and reasonable way. As you can see here, that's where it comes back to, and it goes into the different prongs, right? There's been a lot of discussion about the fair and reasonable, and also compared with the non-discriminatory. I think you'll hear a little bit more about some case decisions on that coming in the next presentation. Now, one thing that's important to note, again, is that if you look at the overall issue with technology development, it's almost, in essence, a circle of life. And what I mean by that is that you pour the revenue into the research and development and technology, and then in return for that, it generates the technological advances that are used in the cellular space to make the phones work better. Then the licensing revenue you receive from that goes back into that technology, back into the research part of that to, again, continue to make the cycle go. And as we mentioned a few minutes ago, we're already working on 6G today. If you look at the investment that we're making in this in R&D, it is very significant. And you can see just an idea of the numbers. Those are SEK, which is the Swedish currency numbers, but you can get a better idea by looking at the percentage of net sales. And I think it's also very interesting here to look at the number of employees that are doing that. As you notice, we've increased each year. In this past, at the end of 2019, we were over 25,000 in the 54,000 patents that we mentioned before. Now, what is the difference between a standard essential and what we call an implementation patent? We talked to you about the standard essential. Those are patents that have been declared and brought in to the particular standard. In the case for cellular space, it's the ETSI standard. An implementation patent is what I would call more of what you think of as a traditional patent. Doesn't have a declaration, it doesn't have the friend obligation attached to it, and it would be more typical as you would see in a general patent litigation case where you don't have the same constraints as to the need to follow the friend contract. Why patents? Quite frankly, they are a very, very important part of technology development strategy. One, it protects the right of the inventorship. You want to encourage people to go out and put the time and the resources into making better solutions, but they need to have protections for that. Two, the licensing revenue enables further investment R&D. Again, when I was speaking to you before, it feeds the further innovation, and it comes back to make things get better. Ericsson's philosophy, I think a lot of the large patent portfolio holders do file internationally. And you can see here, these are just exemplary filing jurisdictions that we do often file in: EU, US, Brazil, India, China, and also Japan. And there's many others as well. When I spoke to you earlier about the large application, it's interesting to get down to a little more detail here when you can see just how massive of an application it was. We had 130 inventors listed, encompassing over 400 pages of information in the application. The application has issued in Europe and is also issued in the United States, and there's other jurisdictions that is still working through the prosecution process. When you go back to the issue with friend, why do we do that, right? You do want to have access to the standard in a very open way. So what's that mean? Well, basically it means today that if you want to log in on the internet, you can download the standard on your computer for free. In other words, no one's going to make you pay a fee before you're able to get the technology that people have contributed, not just Ericsson, but other contributors as well have contributed into that standard. And that makes for a very interesting situation, though, right? Because we talked about it earlier about the patent holder having an obligation on them to be sure that they license their technology in a fair and reasonable and non-discriminatory basis. There's not a reverse commitment on the implementers or people seeking to use the standard to enter into the cellular space, for example. And that's what causes sometimes when you see that you do, as we talked earlier, the need for enforcement litigation. You look at a situation there where if you can get it without having to pay for it, initially, there's always going to be a reluctance to come up and pay. Not always the case, but oftentimes the case. And negotiations can go on oftentimes for years trying to get someone to take a license for the use of the technology. And that's what I was just talking about there, is the term often you refer to as holdout. Another issue that you're seeing internationally across the globe is the intersection of antitrust law with FRAND jurisprudence. And you are seeing some clarity of that in some jurisdictions, particularly in the US. You're seeing where the US Department of Justice is saying that really that's not the space, that the FRAND obligation is a contract issue and should be resolved under breach of contract actions, not brought in to the antitrust realm. In the end, what do we all want? I don't think anybody really is overexcited about the cost and expense and uncertainty of litigation. You just want to get people to license and enter into good faith negotiations. And I think that's best achieved when you have fair and consistent treatment to all the players and the whole system continues to grow and flourish. All right, thank you very much. I'll go ahead and stop sharing.
Thank you very much for the brilliant presentation, Robert. I will just switch now to James. James, if you could please share your screen with the presentation.
Okay, so I'm sharing that now. Hopefully you can see it.
Yes, very well. Thanks.
Excellent. So good afternoon. Thank you to ABPI to inviting me to speak here and enjoy this session with you. I'm going to speak about recent Supreme Court case law in the UK. It's in the context of the previous generations of the telecommunication standards, but importantly sets the framework for how 5G patents will be dealt with, at least in the UK courts. Okay. Right, so I'm going to talk a little bit about the case history. It's actually two cases that were heard together in the Supreme Court. And once I've gone through the background, I'll then summarize the issues that the court addressed and then go into each of those in a little bit more detail. So there are two cases here, the Unwired Planet case, which is addressed on the left of the slide, and the Conversant case. So in Unwired Planet, proceedings were originally brought against Huawei, Samsung, and Google as handset manufacturers. And the allegation was of infringement of 5 standard essential patents. So there were some technical trials first to establish the infringement and validity of the patents in question. And following those trials, before getting to this question of what's FRAND, what's fair, reasonable, and non-discriminatory, and what relief might be available to Unwired Planet, both Samsung and Google reached settlements with Unwired Planet. So by the time the FRAND issues got to trial before Mr. Justice Burse at first instance, it was only Huawei that was left in the case. And what Mr. Justice Burse did was he looked at the situation and the facts between these two parties and the patents concerned, the whole portfolio of patents, not just those that were specifically in issue in the claim. And he determined the terms of an entire FRAND license. So not just the rate, but the entire license terms, and actually annexed to his judgment a license. And the idea of Mr. Justice Burse was to say that these are the license terms that are available to Unwired Planet and Huawei. If Unwired Planet doesn't want to enter into those license terms, then the usual relief for patent infringement, an injunction, won't be available. Similarly, if Huawei doesn't want to enter into those FRAND license terms, then it may face an injunction. So the UK court wasn't imposing FRAND license terms. It was determining them and then using those terms to cue whether or not and how the normal UK relief applied. And importantly, the license terms on the fact of that case were global license terms. So at the Court of Appeal, the court essentially upheld Mr. Justice Burse's decision. And so Huawei appealed to the Supreme Court. And in the Conversant case, the history is somewhat different in that case started with a jurisdiction challenge. So again, there were standard essential patents, a patent claim in issue. And there was this question of a FRAND declaration. So the court was being asked again to set FRAND license terms. And Huawei and ZTE, the defendants, challenged the court's jurisdiction. And at first instance, the late Mr. Justice Carr said that the English courts do have jurisdiction to set FRAND terms in these circumstances. That was then upheld in the Court of Appeal, and Huawei and ZTE appealed that decision to the Supreme Court. So these two cases were then brought together because they were considering the same type of subject matter, not exactly the same issues, but overlapping. And what that left the court to decide were these five issues. So the first issue was whether the English courts have jurisdiction to determine global FRAND license terms. Is that something the UK court can do? Then the second issue is, even if that's possible, should the UK court do it? So this is a kind of common law concept of, is England the most appropriate forum for that type of determination? So the third issue related specifically to the non-discrimination aspect of FRAND. So fair, reasonable and non-discriminatory. So how does that limb of FRAND work? And the fourth issue is about the guidance given by the Court of Justice of the European Union in the Huawei ZTE case. And that was guidance that's binding on the UK court. And it was guidance about how the parties to a FRAND licensing negotiation should behave and the impact that might have on the availability of injunctive relief. So the question was whether the UK court had applied that correctly in its cases. And finally, the fifth issue was about the equitable jurisdiction to award injunctions. So injunctions are a discretionary remedy. They're the typical remedy in patent cases. But the question that the court was asked to consider is it appropriate and proportionate to award an injunction in these circumstances where FRAND is an issue? So I'll now go into a bit more detail on these five issues. So firstly, on the question of jurisdiction. So the question here is whether the court has the power, without the parties agreeing, to consider these issues and potentially, as I said, what Mr. Justice Burse had done, grant an injunction restraining infringement of a UK standard essential patent unless the defendant enters into a global license. And it's this global consequence that was of particular concern. And as I emphasized, the court was determining not just the rate, but all the other terms of this global license. The arguments against jurisdiction essentially came down to this. First of all, the idea that in determining a license, the court was somehow compromising foreign patent rights. So in entering into a license, there's some view taken about the validity and infringement of foreign rights. And classically, that's not something that's within the jurisdiction of the court. So the English court can't come to a view on the validity of a patent in Brazil, for example. So the second argument was about the distinction between what may be agreed commercially and what a court should impose when the parties can't agree. So the idea was there's an acknowledgement that global license terms were actually common in the commercial world, but is it something the court should impose simply because that's common in that different context? The other idea was about disproportionate consequences of being blocked from entering the UK market relative to the implications of a global license. And finally, this idea of comity. So that's really whether the UK court should be interfering with the processes of dealing with FRAND in other jurisdictions. So other jurisdictions may have a different approach to various issues, for example, non-discrimination. And so by taking the approach that the court has been taking, is it interfering with that process in a way that's inappropriate? So the English courts had, at first instance, and the Court of Appeal said that there was jurisdiction, and the Supreme Court essentially agreed. And the first point that the court emphasized, and it's something that Robert picked up in his presentation, that the Department of Justice in the US has recently commented on as well, is that what this is really about is that contractual issues arising from the ETSI IPR policy. So ETSI is the standard setting organization, one of the ones involved as a member of 3GPP. And what the English courts were doing when they were determining a global FRAND license, it is basically ruling on a contract. So it's really about a contractual issue. The other critical point is that the court felt that in setting global FRAND terms, that didn't involve the English court purporting to rule on validity and infringement of foreign patents. So the court acknowledged that wouldn't be within the jurisdiction of the English court, but in setting FRAND license terms on a global basis, that wasn't trespassing on that subject matter. And the court noted that an implementer, like a licensee, would be free still to challenge patents and seek to change the royalties in a license if the challenge was successful. So that's the first issue. So the second issue is whether England was the proper forum, and this arose in the Conversant case. And so in that case, the appellants, Huawei and ZTE, said that China rather than England would be the appropriate forum. And the Supreme Court disagreed with that. On the facts of the case, the Supreme Court said that there was no evidence that China was really an alternative, in the sense that there was no evidence that China would set global FRAND license terms. So that was really the core reason for the decision. But the court also observed that it felt the case was best characterized as one that was arising in the infringement of UK patents, and that the FRAND issues arose from that infringement of UK patents and were necessary to resolve the relief relating to the UK infringement. So there was a hint there that they would have, in any event, considered England the appropriate forum. So there's also a case management aspect, because the court was asked to consider, well, even if the English court is the appropriate forum for considering relief, like the question of whether an injunction is awarded, and to consider that, you need to be thinking about FRAND and whether offers that are made are FRAND, so the license terms that are available FRAND terms. From a case management point of view, there was the possibility of, well, you could let the Chinese court do that, stay relief in the UK, and then come back to the UK once the Chinese court had resolved FRAND issues. And the court said no, basically because on the facts, it wasn't clear that the Chinese court would consider global license terms. It was only looking at Chinese patents. And second, there's a critical issue about the age of the patents in question. So where, the risk of delay is that patents in the meantime, the term of injunction available on a patent, because it's limited in time, is always decreasing. So the amount of relief effectively available to the patent holder will decrease if there's undue delay. And that was a factor that weighed in the balance for the court. So the third issue is this limb, this non-discriminatory limb. And the appellants were arguing that should mean effectively a most favoured licensee clause. So you have this idea that if another licensee has achieved a really good deal, then should an implementer that's in litigation with an SEP holder be able to say, well, I want that favourable deal, I want the best deal. And effectively, that's what Huawei was saying. And on the facts, the deal they wanted was the one that Samsung had got when they settled earlier in the case. And the lower courts had said that, that what they're asking for is what Mr. Justice Burst called hard-edge discrimination. And he said that the license must relate to the true value of the SCPs being licensed. And, you may have given a better deal to someone, and that doesn't mean that an implementer will necessarily get that deal. What they should be held to is the rate that reflects the true value of the SCPs, rather than the most favorable commercial deal. And part of the thinking there is there may be a whole host of reasons why an SCP holder would give a more favorable deal to someone in certain circumstances where there's another business relationship or some reason to give a better deal. So the fourth issue relates to the CJEU Huawei ZTE case. And that's a set of guidelines to ensure that an SCP holder doesn't abuse a dominant position, assuming it has one by virtue of owning a patent, when seeking an injunction. And the Unwired Planet case actually commenced, the proceedings were issued before following all of the steps set out in those guidelines. So Huawei argued that Unwired Planet shouldn't be entitled to an injunction, come what may. So even if FRAND license terms have been set and Huawei doesn't want to enter into them, there should be no injunction because these guidelines haven't been followed. So the court said that the fact that you depart from these steps doesn't mean it's necessarily abusive. But the one mandatory step that is required is notifying the implementer before issuing proceedings. So that's the UK court's approach, which has now been upheld by the Court of Appeal. And the guidelines should be viewed as a safe harbour to avoid abuse of a dominant position, but not necessarily required on the facts in every case. So finally, there's this new issue about discretion over injunctive relief. And Huawei was arguing that the court should award damages in lieu of an injunction. And the idea was the claimants in these cases were patent assertion entities. So the argument was that really it was just a claim about money, and therefore damages should be an adequate remedy. And it's certainly correct that the court has discretion over whether to award an injunction. And what the Supreme Court said is that damages are not an adequate substitute. And they specifically considered the example where if the only remedy was a monetary one, a SCP holder would essentially have to go for each patent by patent, for each country by country, in order to recoup all the royalties that would be due under the portfolio for all the activities of a single implementer. And that's just essentially unworkable. So really that decision is about incentives, and the injunction being necessary to incentivize implementers to enter into FRAND license deals. So that's the end of the points that the Supreme Court considered, and hopefully a helpful summary, and concludes my presentation.
Thank you very much, Robert. It was very clear, and thank you for bringing this important judgment for the whole IP community, and it's of global importance for sure. So thank you very much. So now we are going to start the questions, and again, the audience, feel free to make the questions through the chat, and at the end of the table topics, you'll be able to raise hand and directly ask the questions, okay? So I have a first question, maybe to Robert and James. So basically, what are the key differences between 5G and previous generations? We know for sure that it conveys a much broader range of applications, like the ones related to Internet of Things, and maybe most importantly, what is the impact of such differences on the licensing model? Can we expect a shift from license to all to a use-based licensing model? So this would be my first questions to James and Robert. Maybe James, you may start, and then Robert.
So that's certainly been an issue that's debated. I mean, it's interesting with 5G that the applications are much broader, and Robert touched on that in his presentation. The standards themselves are also broader in the sense that the standards aren't solely related to the radio interface. There are standards, that relate directly to connectivity with cars, for example. So there's no question that it's broader, and there has been a debate about what's the right licensing model. The licensing model that's been used in the telecoms industry commercially to date hasn't been a use-based licensing model. That's not the approach that's been taken. And so the question is, what's the right approach for 5G? And, it's something that has been considered by the Commission, and there was lots of lobbying in both directions. And in its communication on standard essential patents, the Commission essentially didn't come to a view one way or the other. So I think this is still something that is an issue that's yet to be decided. One of the themes, perhaps, in the presentations to pick up is what the license rate should really relate to is the value of the technology contributed. I mean, there's part of the debate comes from the idea of percentage-based royalties. So if the royalty is a percentage and you apply that percentage to a net sales price, then when you're looking at a much more valuable product, that's where, that, like a car, for example, that's where the issue arises. So there's no perfect solution, but one can think of a per unit value that can be applied to products, or a percentage-based thing, and you can perhaps have a cap or a floor that applies. So there's a number of ways of trying to solve that problem.
Thank you, James. Robert, do you have something to add in this first question, please? Thank you. Robert, you are on mute, sorry.
There we go. Better? Okay. So I think one of the key things that James brought out, I think is the core of this whole issue is in reality the value that the technology contributes to the device. And I agree with him as well that there will be a probably broader spectrum of uses for this. And that is, we've seen where things have already happened now. And I think with the car industry, it's obviously a big one, but I think you'll see other verticals that will emerge. But I think what you have to do is you have to look, I think it is each vertical is a separate silo, so to speak, right? So I don't think there's one price fits for everything out there. And you have to, evaluate on a particular basis. And in reality, what is the cellular connectivity doing for this device? How much does this cellular connectivity enhance the value or the operation of this device or the consumer experience using the device? And I think that's how you do it. If it's something, for example, that may have a more limited interaction, then maybe it won't be as valuable as when you walk around with your phone and people interact on a regular basis, almost some people nonstop, right? To something maybe it's sending out data, once a week or once a month, and you can see it's not an easy formula to do. I do think that the cap and floor thing is a very important concept as well. I think the value of the cap is to try to prevent a situation where maybe the base price is higher for reasons other than the cellular connectivity. And I've always used the example of, someone wanted to have a 14-karat gold phone with diamonds all over it, right? That's going to be a lot more expensive than the phone we normally buy, but obviously the cellular connectivity had nothing to do with the gold and the diamonds, right? So there, you put a cap in to avoid situations like that. On the other side, the floor there is to say that if someone were to give away a phone, for example, there's still value in the technology, right? So you need to have some minimum value that the person has, even if there's a rationale for giving the phone away, because you may have adware on it or different things, different revenue generation aspects besides just the actual sale price of the phone. So I think that's a very big part. And again, I think as James said, this is evolving, and I do believe that if we were to come back here a year from now, there's probably going to be new things that we hadn't thought about that are going to grow out of the 5G expansion as that generation begins to take hold and mature.
Yeah, just to pick up something you were saying there, Robert. I mean, one of the interesting things is whether the companies contributing to the initial technology in a standard should have a share of the benefits, not only the value of that technology, but what's then added on top. So one can think of the standard as creating a platform, like an ecosystem that allows further innovation to take place, and there can be whole new business models that are generated on the platform of that technology. So there's a revenue that's generated from that activity. And so the question is, should the people originally contributing the technology that enables that platform have some share in that revenue, or should that revenue fall just to the people who are implementing downstream the technology? And it's an interesting question. I mean, it's something that the UK court did touch on, and Mr. Justice Burse in the Unwired Planet decision took the view that it would be appropriate for the SEP holders contributing the original technology to have some share in that added value of the standard. But that's perhaps one of the more controversial aspects of his judgment, and not something that was specifically addressed in the appeals.
Yeah, I think that's a very good point, James, and I think it raises two issues, right? One's always the interesting thing about exhaustion, right? Where in the chain do you select to assert the patent rights and royalties, and what impact does that have on the rest of the chain? But I think you've seen a lot of cases recently coming. I say a lot. I know for the FTC Qualcomm case recently came out with this holding. There's the most current one. It says, look, the SEP holder has the right to determine where in the value chain that they want to seek to receive the value for the innovation. I think the value is still tied to the technology contributed, but I think that the courts are not trying to take a very rigid view that you have to go this way or go that way. It's oftentimes what makes most sense. And I think from the cellular perspective, I think industry practices show that in that context, going at the handsets has made the most sense. So that's what people are licensing on right now worldwide.
I guess the next question would go to, you both touch base on this aspect, which is the licensing terms and friend terms, but what might be the geographical scope of friend licenses within the 5G realm? Would be there any differences in relation or associated with this new model for 5G in terms of also enforcement of the technology before different countries, before courts within different countries? either of you, I guess.
Maybe I'll take a stab at this one first, and I'll pass it over to James. Right. So, I think if I understand correctly, it's does the increased scope of 5G indicate a major shift in how we see that people are going to try to get licenses and the methods upon which they do them. I think as I went to a few minutes ago, I think you will see different verticals, and I think that the verticals will shift to different probably licensing structures and methods for those verticals depending on how they're used, and as we said before, the value that is given to them. I don't see personally a big shift in the enforcement strategies. I think in the end it's going to come down to showing that the patent has in fact been infringed, is valid, and is essential to the standard. And that's, again, the ramifications of that showing will be likely different, how you do that for the various verticals, but I think that the core techniques are going to be the same. I think, I didn't understand, did you have a question about the rates in that one too? Make sure I've answered you completely.
No, not yet. Just
okay. Okay. All right, I'll shift back to James then.
So I think from the perspective of the UK court, whether a FRAND license should be global in scope depends upon two things. The first is whether both the patents and the patents of the patent holder and the activities of the implementer in question are global in scope. So if you have a global patent portfolio and then a global infringement in the sense that the technology is being used on a fairly global basis, then that points towards a global license. That's the first thing. And then the second thing is what the practice is commercially. So, for example, if a particular patent holder, an SCP holder, already has a number of existing licenses that are all global in scope, then that establishes fairly strongly a pattern of global licensing. And one of the, a strong factor in determining what terms and what rates are global is what has already been achieved for the portfolio in question. So I think it's looking at the facts of how is the portfolio made up and what's the scale of the infringement, and then also the kind of past behavior of what the particular SCP holder has done. I mean, it's interesting that then perhaps becomes tricky when you're looking at a new use case, a new vertical, as Robert put it, where there perhaps isn't an established practice. But I think it then comes down to the question of, well, is the sale of the products, the infringement, global, or is it, nationally restricted somewhere?
Okay, very clear. So I have another question. We know that transparency plays a big role in FRAND. So in the sense, what would be the significance of published rates, and what we do know about 5G license rates? So published rates and transparency, that would be my question. I don't know if Robert would be comfortable to answer this one.
Sure, I'm happy to start. So look, I mean, as James alluded to earlier, oftentimes when we do have established agreements, we feel like comparable license agreements that are negotiated and with very sophisticated companies with arm's length negotiations provide the best roadmap or evaluation for what the portfolio is. I think you can have a situation, though, as we have now, for example, where we are shifting from one generation to the next generation, and we will possibly have some of the same issues that James mentioned, too, if you're going into a new vertical, right, where you don't have those agreements out there. What Ericsson chose to do was to be very open with the world market about what we thought the value of our contribution to 5G would be. We came out, I believe, it was in 2017, with an ex-ante statement telling the world that 5G is coming. We're a big player in that space, and we're anticipating contributing technology. And by the way, this is what we envision the price would price would be. Now, obviously, over time, you'll get some more comparable license agreements in, and that begins to have a stronger anchor than the prediction that we're making at the very beginning. But I think it helps put the world on notice of what we're looking for, and I think that's very important because that statement was made prior to the standard being locked in. So in other words, if you didn't like the price, you could use someone else's technology, right? So it was trying to be very upfront with what you were, in essence, buying in maybe a loose sense before you chose it to go into the standard.
Perfect.
I mean, Robert, you'll have a much better idea of the history of this, but my understanding is, in terms of previous generations, is there were a large number of public statements for LTE. I don't think they were ex ante or before the event, as you just said. They were, after the first release of LTE. And in GSM, there was much less public information, so the transparency's kind of gradually increased.
Yeah, I think it's increasing some, and I think it's over time you'll learn. So there were a lot of articles that were published, and I think back when you transitioned from 3G to 4G, people just didn't know, right? That there was an uncertainty as to the increase in the average sale price of the phones, and just really trying to figure out what is cellular going to be in this new space. And as we now know in hindsight, right, the big game changer for 4G was streaming video. People could watch movies and you had a lot more access. And I think when it first came out, that was still, I think no one really predicted how strong that would be over time when it came through. What we kind of looked at this time was trying to look back and see what was the transition from 3G to 4G like. And as best we can, let's make a prediction on how the transition will come here from 4G to 5G, right? And again, our preference is always that once we establish enough comparable license agreements, much as you talked about earlier, that's our preference to go back to establish valuation of the portfolio. But when you don't have that, you need something. And we thought this was a good, straightforward, clear way to show the world business world what we were tending to come out with.
I mean, I guess a related issue, we're talking about the passage of progress through the different generations, is how one deals with the fact that phones are often multi-mode. So you still have the previous generation technology in a device. I mean, that might not always be the case. But it's an interesting issue how the generations, I mean, you alluded to it in your presentation that the work for 5G began about the time where 4G was going into use commercially, widespread use, and some of the work on 6G starting now. So these things are all overlapping the timelines. And the technology in use actually overlaps as well. So perhaps it might be interesting to talk a little bit about how you see the multi-mode value in phones.
Yeah, and maybe I'm gonna use a different device for an analogy to think about this, right? I mean, think as a generation continues to age, right? Theoretically, the value can decrease some because new stuff's coming out, right? And I think maybe it's very clear in my mind. I think about a television, right? If you go in today and look at a TV, they're bigger than the one before, and each time they come out with a new thing, the one before gets a little cheaper, and the ones that's coming out now is the newest, greatest, is a little higher. And I think the same thing you'll see with the technologies. Obviously, it's all tied back to the value. But at least the way that we've looked at pricing, we'll price at the highest generation of multi-mode phone, right? So for example, we're not going to give you a 5G tick. We're going to say, okay, this phone with the 5G technology, any other generations it can also accommodate, which most phones do that, as you said, is going to be X price. You traditionally have seen a jump from a generation to generation, which you would expect to see, and then you will see as people in essence begin to commoditize some of that technology, it will get cheaper over time, and then you'll have another bump when you come up to the next generation following it.
Fantastic. And turning a little bit more to the litigation side, I am a litigator, so I'm really eager to see your view on that, to hear actually your view on that, especially because this was a very widely debated topic here in Brazil. In the very few cases we have concerning standard essential patents and how they play out before courts. So the question would be, why are injunctions necessary as a potential remedy when the business of licensing is essentially about collecting money from the technology put out there? And maybe James will feel more comfortable in addressing this question first.
So that's something that the Supreme Court decision I was discussing in my presentation, grappled with. And, in particular, there was an argument there that particularly in the case of a non-practicing entity as a patent holder, should damages be enough? Traditionally, the UK courts have had some sympathy with the idea that when a case is essentially about money, is there a need for great haste? And I mean, it's interesting that in a FRAND context, there's a real tension there with the whole idea of FRAND negotiations in good faith, because the way from a UK perspective, the contractual framework works in the ETSI IPR policy is that it's an obligation on an SEP holder, but in order to take the benefit of that obligation, an implementer must also kind of comply with certain requirements, specifically to negotiate in good faith. And what we see in the Huawei ZTE CJEU case is that a really important component of that is avoiding delay. So I think it's pretty clear that in order to benefit from the FRAND commitment that an SEP holder gives, an implementer has to avoid delay. Delay is a bad thing. But if we stop and think, well, why is that? If this is just about money. And I think it does come down to this idea that there are a large number of implementers of the standard. As Robert was saying in his presentation, it's a technology that's already been essentially given away. At the time the licensing discussions are happening, the technology is generally already being used by the implementer. So commercially, it's an extremely difficult starting point for a negotiation. Please, will you pay me for the thing that you've already received? It's not what happens when one goes into a shop and has to get your wallet out. And it is potentially a difficult discussion, and one also has to appreciate that with this vast number of implementers, a vast number of patents, and a large number of jurisdictions involved, in order for the SEP holder to get back all the royalties that are due, there's like a mammoth logistical exercise. If you imagine that you have to enforce each and every one of those patents against each and every one of those implementers in each and every jurisdiction, you would be litigating for longer than the standard remains relevant, potentially, in order to get the royalties that would be due on a fair, reasonable, and non-discriminatory basis. Now, that's not necessary because there are many companies that negotiate on a proper commercial basis in good faith and resolve these issues. But in cases that that doesn't happen, and so that's why the UK court has said that an injunction is still relevant and necessary. It's to incentivize recalcitrant, unwilling licensees. But there's a limit on it, because in order to get that injunction, the patent holder also has to act in good faith. So it's really important. It's central to the way ETSI was set up. And it's really important in the court decisions that there's always a balance between the competing interests.
So maybe to add a little bit to that, right? So as we talked before, that we agree with you on the European side that you haven't, you're trying to have a reason not to delay, but that's still not necessarily a worldwide concept. I mean, some courts have adopted it. What you see though right now is, and what everybody wants to do, as we finish up with the second to last slide in the deck, is look, just come to the table and negotiate in good faith. If you have a situation where there's no injunctive threat and all you're going to have to do is pay, why not hold out to the very, very last minute you can, right? Because if worst case, if I can delay this trial for 4, 5, 6 years and come back in and pay what I would have had to pay at day one, that's a win for me, right? So there's no negative incentive to get him back in. I think when you do have the injunctive threat, and look, keep in mind, nobody wants, in the truth be in, just come in and negotiate it in a fair and reasonable way, and then let's get the thing worked out. Oftentimes when people want to hold out and they say, well, it's not my problem, it's you're just not making me a friend offer. If you made a friend offer, I'd have taken it in a heartbeat. Well, obviously we're going to agree oftentimes what fair, reasonable, non-discriminatory stands for. But what we have done in those situations is we do this. Okay, I respect your belief that the offer we're offering is not friend. How about this? Let's go into arbitration. You make your argument, I'll make my argument. Let the arbitrators come out with a friend rate, and you start paying. You may be surprised to know that has only been accepted one time in all the cases I've been working with, and we have over 100 licenses, and I've had over 100 licenses executed while we're at Ericsson on FRAN type agreements. So, look, in the end, there's a strong desire to delay as long as they can, and they do everything they can do that. The injunctive elements give you some degree to bring that back in. I'll note that Brazil, in my view, is one of the front runners in addressing this with the early chances for preliminary injunction. If you can show, and again, the complaints in Brazil are very robust. So that, you can see from the complaints and expert information in there that there is, a high degree of potential infringement from there, and it gets the parties back to the table to at least try to start getting things worked out. India has taken a similar position as well in their court system. I'll make one final fun statement, I guess. When James was mentioning it before the generation dies, I would go as far as to say that if we have to litigate every patent in every country, it would be my granddaughter carrying that litigation forward, not her grandfather. So it's almost